Good afternoon to all participants in the online public hearing organized by the Independent Evaluation Commission for assessing the integrity of candidates for the position of member in the self-administration bodies of judges and prosecutors pursuant to law number 26/2022. I hereby declare this online session open. This hearing involves the resumed evaluation of Mr. Anatolie Gîrbu, candidate for the Superior Council of Prosecutors and Deputy Chief Prosecutor of the Ungheni District Prosecutor's Office. I would like to welcome you, Mr. Gîrbu. We are here to conduct an online. We are here to conduct an online public hearing in the context of the resumed evaluation process aimed at assessing candidates for the position of the Superior Council of Prosecutors. The Commission is acting in accordance with Law number 26/2022 and its rules of procedure. On the screen in front of you, you have the 5 members of the Commission: Victoria Henley, Nadezhda Rybczewski, Tatiana Raducanu, Nona Tsutoria, and myself, Herman van Hebel, the Chair of the Commission. The Commission is also assisted by members of the Secretariat, and the online public hearing can also be followed by the representatives of the media and the public. And those representatives are advised not to use the camera and to have the microphone muted. During the hearing, interpretation between Romanian and English will be provided. To allow for accurate interpretation, I would kindly ask you to speak clearly and slowly. Furthermore, the proceedings are being recorded and the public parts will be available online generally within 24 hours after the hearing via the website of the Commission at www.vetting.md. I will start with a brief overview of the procedural background of this resumed evaluation. On the 2nd of June 2023, the Commission issued a decision.
If I may, esteemed Chair and Chair of the Commission, esteemed members, I would like to cut you off. Before we start the hearing, before you make the presentation, I put down an application. I wrote an application that I would like to put forward. I wanted to forward it to you as a president, the chair of the commission, and to the other members. It's that none of you is present here, so I don't know, maybe somebody from the secretariat could pass this over, but it's an application, a request, and I could tell you out loud what this request says, if you allow me.
Can you please briefly explain what the request is about?
This request is about, well, considering the context of the prior messages that I received from the Secretariat of the Pre-Vetting Commission, and it also has to do with the requests that I filed to the Commission through the Secretariat, my requests to the Commission through the Secretariat via electronic mails, by email. These were requests that I did not receive a response to. I did not have a clear response to those requests that I had. And in this context, today, at my request to look into the administrative case, I've received a reply to that today between 1 p.m. and 2 p.m. today on the 1st of November 2023. There are 3 volumes here, about 300 pages, 400 pages, and I did have a quick look at them, but I did not manage to have a thorough look at it and to look at the essence of it. And therefore, for this reason, and this request that I've written, well, at the same time, I didn't see in these materials, as far as I looked, as far as I managed to see in volume 3, following the decision of the Supreme Court of Justice, I did not find the minutes of the meeting at which the Commission took note of the receipt of the decision of the court from August 2023, and I didn't see this in the minutes, as in what the Commission will do to execute the decision of the Supreme Court of Justice. So I did not see any minutes as to that. That's why I have a written request developed for this purpose, because it's only today that I was able to look at these materials insofar as I was able to. And I would like to highlight that these are all copies, and this is of importance given my request that you will receive. So the first thing that I put down in this request is that I would like to be issued a copy of the minutes of the meeting where the Commission received and analyzed the decision of the Supreme Court of Justice of 1st of August 2023 and the decision of the Commission regarding the implementation of that decision of the Supreme Court of Justice. So what the Commission, when the Commission took note of that decision and what the Commission would do to implement that decision, I would like to have a copy of the minutes of that meeting where this was discussed, and I would like to be given a preliminary partial final discussion, conclusion, of the evaluation commission, and that was previously sent to the mailbox without having been signed. Or, as it turns out of the regulation, though, the rules of procedure of the preventing commission, the preliminary conclusions, like the partial or final conclusions of the evaluation, shall be examined by the members of the commission in meetings and concurrently, according to Article 3.1, the chair of the commission exercises due to the letter B shall sign the minutes of the meetings and shall sign the letters and decisions. So I wanted to have the signature of the chair of the commission on documents like this. And the third request of mine has to do with, well, is a request of mine. I'm asking the commission to ask from Banca Sociale. I'm not sure it's, as far as I know, insolvent now. So to ask from it the presentation of original documentation with regards to those two bank accounts that have allegedly been registered under the name of my wife, Gîrbu Ramila, so as to be subject to an expert review, so as to establish with certainty who signed on her behalf, because previously I did ask this of the Commission through the Secretariat. However, by a message I was confirmed that they've received the document in copies, in the form of copies from the bank. And I did not receive, I was not told if my request was accepted or not about the expert review for those signatures. I mean, in the copies, certainly if you were to do an expert review of the writing, on those documents, it is not possible to provide an expert review on copies. So that's why I asked for the documentation for the original versions of the documents, and I was not given a clear response in this regard. Why wasn't this documentation requested in original format from that bank? Because at the Supreme Court of Justice, I submitted this application on behalf, in the name of my wife. I wanted to submit to the Commission evidence on my own, and I provided that application on the name of my wife that she filed with that bank. I submitted it, and also we submitted the response of the bank, but the bank said that it refused to issue those documents, and it mentioned that they could only be issued to competent bodies, to empowered bodies, and not to her. So these are documents that she allegedly signed herself. So I don't have the possibility to obtain those documents, and I cannot order or request personally an expert review on that. So these nuances are essential for that
Mr. Gîrbu,
issue.
Mr. Gîrbu, may I briefly interrupt, because we have a number of requests that you submitted to the Commission. Of course, you can submit.
Eu am înscris, îmi cer scuze, am înscris.
Sorry for cutting you off,
Gîrbu,
but
let me first please
who is
explain.
receiving this?
I will listen to your comments later on, but let me first, as a chairman of the and the proceedings, explain what we are doing. In relation to the first issue that you raised as to having access to the materials, and we see the binder of all the materials on your desk, you were informed in the letter that was sent to you on the 16th of October, in which we sent to you the statement of facts. We also included in that letter an invitation to you to have access to the material. So basically, since 16th of October, you have been able to have access to the material. They were there waiting for you. It is, of course, up for you as a candidate to decide when to pick up the materials, but they were available to you since October 16th. In relation to your second question about minutes of us receiving the decision of the Supreme Court, there are no such minutes. These are just documentations that we receive. We have minutes of very particular aspects of our decisions. Receiving document is not a decision by the Commission, and therefore there are no minutes reflecting the fact that we have received the decision of the Supreme Court of Justice in relation to your case. And of course, all our deliberations since then in relation to your case and other cases have not yet led to any decision. And of course, our hearing today is part of the process leading to a decision. And of course, once that decision is taken, there will be minutes taken of that decision, but that is at the end of the process. There is also no practice that was also during the initial evaluation and also during the resumed evaluation of any signed statements or documents from through the Secretariat to candidates. We have constantly used the practice that the Secretariat, and they are mandated by us to do so, to communicate with candidates. That has never been an issue, has never been a problem also in proceedings with you prior to the initial decision. And there is no need to change that practice. The Secretariat, as you know, and also accordance to our law number 26, clearly states that the Secretariat functions under the exclusive responsibility of the Commission, and the head of Secretariat and other members of the Commission, of the Secretariat, do so on our behalf. And there's no need for each and every communication with candidates to be signed by the chair or any other person of the Commission. And in relation to your last request, as far as the a copy or an original of the signature of the bank, we have, as we also explained to you before and also confirmed in the letter yesterday on the 31st of October, we have been in contact with the bank. The bank has not been able to provide the original, and therefore we have not been in a position to provide you with that original. So I think that is in response to your written question. That is an oral response. Of course, feel free to submit your written text to the Secretariat that is with you at this very moment. And of course, the Commission may deliberate later on in what shape or form we would then continue to respond to the questions that you have. But just I would propose that we continue with the hearing as we have it. As I was saying,
dacă îmi permiteți totuși până la urmă să mai expun.
But if I may
very briefly,
cut you off
yeah.
and continue my train of thought. Well,
But Mr. Gîrbu,
regarding
may I first,
Indicațiile pe care le-am primit.
Mr. Gîrbu, there's a procedure that we have in place.
Deci eu în
As Commission, let me please finish. As
Eu
Commission,
sunt de
we have a
acord.
procedure in
Vă
place.
permit.
And during the hearing, you can at any time give an opportunity. You have an opportunity to provide feedback to the Commission, but the Commission is in charge of organizing its proceedings, and I would appreciate if you would cooperate with the Commission in doing so. So I would like to continue with the introduction. Then we will get to the issues that have been raised with you, that have been reflected in the statement of facts, of which you had an opportunity to respond to. And of course, during the hearing, there is an opportunity for you to raise any other issues. You will be given ample opportunity to comment on any issues that you have with the Commission, but that will come at a later stage during the procedure. So let me continue with the order of the
Domnule
proceedings.
președinte, dacă îmi permiteți,
If I may cut you off, Mr. Chair, you didn't let me to finish in the context of the request before we start the public hearing. I asked you who could I hand it over to, and with regards to these requests of mine, I have another request. As I said, I mean that I actually did not look at all the materials in the case file to make sure that everything is properly prepared for the hearing, that I'm properly prepared for the hearing. I did not manage to familiarize myself with a case file with this. So I would like to request the Commission to postpone the hearing for maybe a week, another week, so that I have time to look into this information. Yes, you told me about the date of the 16th of October 2023 that I was informed by the Secretariat but of the Commission, but when by message I asked, where could I go to? Where should I go to familiarize myself with the case file? What place? What time? And it's only yesterday, on the 31st of October, that I received a message after 17 o'clock that today I could come between 10 and 3 p.m. I could go to the headquarters of Stefan Chalmari Street in Chisinau municipality. It's yesterday that I received that message, not on the 16th of October. So where could I have gone to? I didn't know where where actually the materials were. It's yesterday that I received this message, and for these reasons, I have this request and the request to postpone the hearing if that is possible, so that I can prepare accordingly. That's the only thing that I wanted to say. Well, to avoid going back again over what I already said.
Thanks very much for that. And as I mentioned in a few minutes ago, in the letter in which you will send the statement of facts and the serious doubts in relation to your case, in that letter that was sent to you on the 16th of October, in that very same letter, you were also invited to contact the Secretariat, because as of the 16th of October, the materials that you have now in front of you were available for you. So you have had more than 2 weeks to actually have access to all the materials. So I think it is a bit of a problem for the Commission if a candidate does not make use of his right to have access to the materials for the last 14 days and chooses to pick up the materials only just before the beginning of the hearing, in order then to submit a request for a postponement where the postponement is not attributable to the Commission. The materials was clearly available to you as of the 16th of October. So if I would like to
Nu mi-au fost puse, îmi cer scuze, nu mi-au fost puse la dispoziție, domnul președinte.
They were not provided to me, Chairperson. No, they were not provided to me. I communicated with the Secretariat. The Secretariat only yesterday evening sent me a message. Yesterday evening after 5 o'clock, when they sent me where to come and from what time to what time. Before that, I did not. So after I received that letter that I can come and access, I asked where can I come, and only yesterday I got an answer where I can come and from what time to what time. I only got yesterday that message that I can come today. It wasn't sent me at least 2 or 3 days ago to tell me that between that date until that time you can come. I received it yesterday, and you can check that. Another
Mr. Gîrbu,
message about where to come.
Mr. Gîrbu, we are aware of the fact that you requested it for the first time yesterday, but what I'm saying is that you were informed by the Secretariat on the 16th of October that the materials were available to you. It was your choice for the first time yesterday evening to contact the Secretariat, but the materials, and you were informed about it in the letter of the 16th of October, were available to you as of that moment. But maybe I would suggest that we take a little break and that the Commission will consider your question whether or not to postpone the hearing. In order to do that, I would appreciate if you would briefly step out of the room where you are now so that the Commission can continue its internal discussions. And as soon as we are ready with our deliberations, we will let you know and then inform you about our decision and then see how to further proceed. So if we can take, if you would like to give us a few minutes, then that would be great. Okay, thank you very much for that.
Cu plăcere și eu vă mulțumesc.
Thank you very much. Mr. Gîrbu, as you have noticed, we have deliberated on your request to postpone the hearing, and the Commission has decided to reject your request. The reasons for that are that the focus of the hearing is on the statement of facts. The statement of facts were sent to you on the 16th of October, and you have already provided answers in writing as well. And the hearing is focused to continue that discussion about the statement of facts. In addition to that, in that message of the 16th of October to you, we also informed you about the fact that the documents were available to you. We also informed you or asked you at that time whether or not you want to participate in the hearings. You did respond to the question whether to respond to participate in the hearings, and that's why you're here today. But we have noticed also that you only contacted us in order to get access to the materials on Monday the 13th at just after 5 p.m. But that in principle was an opportunity that was available to you as of the 16th of October. Under those circumstances, we do not see a reason to accept your request for the postponement of the hearing. So we hereby would like to continue the hearing this afternoon. And I will continue with the script and the opening of the hearing, and of course have a discussion with you on the statement of facts and the questions that we may have for you. So going back to the brief overview of the procedural background of the resumed evaluation, on the 2nd of June of this year, the Commission issued a decision in relation to your integrity evaluation for the position of member in the Superior Council of Prosecutors. In its decision, the Commission decided that it had serious doubts about your compliance with the criterion of financial and/or ethical integrity in relation to two issues. Issue number one was the source of funds for two bank accounts registered in the name of your wife between 2011 and 2015, and failure to declare these bank accounts. And issue number two related to service housing, privatization, and sale thereof. On 16 June 2023, the Commission started the resumed, on 16 June 2023, you appealed this decision to the Supreme Court of Justice, and on the 1st of August 2023, the Supreme Court of Justice annulled the Commission's decision and ordered a re-evaluation. On 8 September, the Commission started the resumed evaluation, and on 16 October, pursuant to Article 19, Paragraph 1, Letter C of its Rules of Procedure, the Commission sent you a statement of facts and serious doubts. On 23 October, you responded in writing to the statement of facts and serious doubts. On the same date, you did inform the Commission that you wished to participate in a public hearing. During this hearing, the Commission will take into account your privacy and, where required and possible, the privacy of your family members and close persons. So we will leave out unnecessary details relating to, for example, ID numbers, bank account numbers, addresses of real estate, and the like. For the protection of your own privacy, we ask you to do the same. The present hearing takes place at your request. The hearing will be focused on the statement of facts and serious doubts that the Commission has sent to you and your written response to the statement of facts. The Commission would like to invite you now, if you so wish, to briefly provide additional explanations to complement your written response to the statement of facts and serious doubts that you submitted to the Commission. I urge you to be concise in your explanations. You will be given a maximum of 50 minutes for each of the issues mentioned in the statement of facts and serious doubts. Afterwards, one or more members of the Commission may have questions for you about the explanations you have provided. In case we will have any questions for you, we will try to keep them short and to the point. And we ask that your answers be short and to the point as well. We also ask you to answer all questions truthfully and completely, as your explanations are important to the Commission in verifying your financial and ethical integrity. I would now like to hand over to Nadeja Rybczewski to lead the discussion with you on the statements of facts and serious doubts. Nadeja, you have the floor.
Thank you, Mr. Chairman. Bună ziua, domnul Gîrbu. Prima problemă pe care...
Greetings. The first issue that we will address today at the hearing has to do with the source of funds for the two bank accounts that were registered in the name of your wife between 2011, 2015, and the failure to declare them. As you've already received in the notification on the facts and in the statement of facts and serious doubts, the Commission has serious doubts about your ethical and financial integrity as regards the source of funds deposited during the years 2011-2014 on the two deposit accounts registered in the name of your wife and the failure to declare them, and specifically about the way in which the two bank accounts were opened in the wife's name without her knowledge, allegedly, and not declared by you. The second is the substantial amounts, totaling about 365,000 lei deposited in both accounts, and the amount that has deposited and withdrawn compared to your and your wife's income would total about 540,000 lei over 2010-2014. And also there were inconsistencies regarding the purpose of those accounts, how they were managed, and what had happened to the funds on those two accounts, considering the explanations that you provided in the written communication with the Commission during your initial evaluation. The statements, the inconsistencies, also in consideration of the statements of the two witnesses heard before the SCJ, your mother-in-law, her brother, and the information provided by the banks regarding the two bank accounts and the funds deposited on and withdrawn from those two accounts. And so the Commission has serious doubts regarding your ethical and financial integrity because of your failure to declare bank account number 2 for the years 2012-2014, which was on your wife's name. And there was substantial financial activity compared to your and your wife's income. As the chair has already announced, now you have up to 15 minutes to provide, if you so wish, a short additional explanation in addition to the answer submitted in writing upon receipt of the statement of facts and serious doubts. Over to you. Thank you, esteemed members of the Commission. I hope I will be able to avoid a repetition as regards these two accounts that were allegedly in the name of my wife, that were opened and closed allegedly in the name of my wife, as I've explained earlier to the Commission during the initial evaluation and during the re-evaluation, and as it was established by the Supreme Court of Justice in its decision of the 1st of August 2023. I would like to mention about this account that about these accounts, I had no knowledge of these accounts. And this came to my attention when questions were asked by the Commission. So then I raised these questions with my wife, and she too was perplexed. And she said that was not aware of it. She doesn't have, and never had accounts like that, especially since, as it says here, and 10, 11 years ago, as it says here. And as I've also provided answers in the messages with the Secretariat of the Pre-Vetting Commission. I noticed that these accounts were opened with Banca Sociala, the mother of the wife, used to work there because Banca Sociala Bank, I'm not sure if they at the end of it or not, but they were amid a process of liquidation, so I'm not sure if that is complete or not. But she was working at the Banca Sociala back in those years. So obviously I and my wife, we asked her if she knew anything about those accounts because actually we did not use that money. It's not our money. We even had no knowledge of that money. And the mother of the wife told us that, yes, she did not inform her daughter, that is my wife, about those accounts because those accounts were opened at the request or somebody following some discussion with, I can't remember all the details of that, but it's just I had nothing to do with these accounts, so it's only out of what I was told. It was for her brother who worked for many years abroad, so it was for the brother of the mother-in-law, and there were some problems there in the family of the brother of the mother-in-law, so they've talked and agreed for her to keep the money because he knew that she worked in the bank, and so that she would keep the money that he was earning in the Russian Federation. So there was a request for her to deposit that money on that account. So as for the management around it, well, not I and my wife, we know nothing about it. We knew nothing about it until it came to our attention via the questions asked by the Pre-Vetting Commission. And this was confirmed both by the mother-in-law, my wife, and the brother of my mother-in-law, I'll put it like that. And earlier, during the evaluation, they were not heard by the Pre-Vetting Commission, but they were heard by the Supreme Court of Justice, and they confirmed these aspects. And it is important to note that, well, how these events would have occurred, like in 2011, they were allegedly open, so it was one of them 10, 11, 12 years ago. So obviously, none of us can know what exactly they did so many years ago and how exactly events occurred so many years ago. It's only that remembering some general information, but the mother of my wife explained it. She said, and it is also obvious in the decision of the Supreme Court of Justice that I referred to. Well, she explained with clarity that she signed on behalf of her daughter. She signed the documentation regarding the opening and the management of those accounts. At the end of the day, it doesn't matter how they were managed, but she signed. My wife didn't know, I didn't know about that. And for this reason, keeping this in mind, my wife subsequently, after the commission decided by its decision of 2nd of July 2023, I'm not mistaken, to fail me, she wrote a request to the liquidator of the bank. She filed a request. Their headquarters are in Chisinau municipality. So she asked for the original documents to be issued regarding those two accounts so as to be able to make an expert review of the signature, of the written signature, the handwritten signatures, to have this handwriting expert review performed in order to figure out who made the signature on those payment orders or whatever documentation was there. I mean, all the documentation related to the management of those two accounts. So in this regard, as I mentioned also in the request that I've submitted, that I've written, well, from that bank, we received a refuse. The bank refused to issue us those documents in original copies, also saying that they would be issued only to empowered bodies. And that's why I then requested the Commission to take action in that regard, because according to the law, the Commission has the right to seek information from any individuals and legal entities in pursuit of carrying out this evaluation of candidates to the positions of members in the SCM and SCP. So we wanted to bring more light into this situation, and we hope there would be a decision, a final decision on the basis of those original documents, or they hope that there would be an expert review of the handwritten signature to finally figure out who signed those documents. If this happened, then that would have been much clearer than a statement made by a witness. And that would have supported a multifaceted examination of the issue altogether. However, without this, without the expert review of the signature, without having my requests allowed for, so all we are left is with the statements of 3 people, and all of them say that I was not aware of these accounts, which is true. I did not know about them. I've never used that money. I never operated with that money. I don't have that money. And in general, I have nothing to do with that money. Yes, certainly I saw in one of the messages from the Preventing Commission Secretariat that it was not possible to open such accounts on behalf of other people because you're not allowed to. There's a regulation that prevents doing that. There's a regulation of the National Bank that provided that it has to be opened in the presence of a few bank clerks. I mean, that there's a regulation with provisions. It doesn't mean, though, that the regulation was necessarily observed. The mother of the wife didn't say that she necessarily observed it. I, at least in my work as a prosecutor, have often come across cases where regulations wouldn't be observed for different loans, people taking loans, for instance. There would be non-performing loans, for instance, and still there would be people violating rules and taking loans on behalf of other people's names. So there are instances of regulations not having been observed. But the money that is there at the end of the day, that money went back to the person who that money even belonged to start with. They were not taken over by us. But that is not of the essence for my evaluation as a candidate. Of the essence is the fact that I was not aware, and the Commission did not provide a piece of evidence that would have shown that I was knowledgeable of it, that I knew of it. There are 3 witnesses that have to do with this case, and they say they didn't. My wife, first of all, she said I didn't tell him because I myself didn't know. That's what she said. And the mother of the wife, who says that she signed on behalf of my wife those documents. And I would like to say that I did not manage to look at each and every page here, but at some of the pages I tried to pay specific attention to, like some decisions. I might have just had a quick look, and I was looking at the copies to see if if the signatures were identical. And albeit I'm not an expert to perform this sort of a handwritten expert review, but if you look to me, these signatures are different. It's obvious that it wasn't the same person doing them. So that was essential. I mean, you could ask me, or you asked me during the evaluation and during the re-evaluation about the management and who and where and what. How could I have answered that if I have no knowledge of that? I didn't manage these accounts, and my wife didn't either. You see, I mean, when we fill in those annual declarations, we ask the members of our family too. Well, because we have to report our income and the income of the family members, and well, obviously, I mean, I couldn't have not no bank would seek. I mean, I couldn't have gone to see or to all banks to ask for bank accounts to see what if somebody by chance opened an account on my name. I couldn't have written this request to all the banks of the country to see if anybody by accident opened an account. But you see, the request that I did write, like in our instance, the bank wouldn't even issue that document. There has to be a criminal case. There has to be an authorization of the investigating magistrate for that, because banking secrets require special measures. So I obviously couldn't have known, even if somebody opened such accounts. And if, for instance, look when certain procedures that are not observed, and sometimes there could be mistakes made as well. So it doesn't mean that I knew. There is no evidence in the file. There is no proof in the messages submitted by the secretariat, and it was out of what the witnesses said. It doesn't come out of anywhere that I knew about these accounts, but that I didn't declare. And first of all, I wasn't aware of them. So roughly, that is my answer, my response. Thank you, Mr. Gîrbu, and I try to be as persuasive and quick as possible. And thank you for that. We'll have a couple of questions though, so please explain it so far as you know the answer. And there are certain aspects that for a while now, though you've been aware about the doubts you had about the accounts, so certainly you managed to clarify certain things. So the first question is about whether you could explain why did your mother-in-law decide to open one bank account, then close it, and then to open another bank account and then close it later, instead of having one of the same account, because the purposes of the two accounts was the same. If you can answer this question, if not, we can ask the next one. You're
Este se aude? Se aude, da. Da, încerc scuze. Deci, eu nu mi-amintesc, fiindcă am și
I don't remember, and this was also raised at the Supreme Court of Justice, because today I've looked at it quickly. I didn't manage to prepare properly, as in to have enough time to jog my memory about it, because as I said, I didn't manage these accounts. I don't know. Now I can't tell exactly what she said about it. I think she answered this the Supreme Court of Justice, when she was heard, and I think she explained the logic behind it, that there's some money continued coming on those accounts or something. I don't know the details of how she managed the money on those accounts. And at the end of the day, she knows for certainty that that happened, but then she still tells me, because I insisted and I kept asking her, and I also had reproaches because as to why she didn't inform us about it, and because now look at the problems that we have. So this happened without our knowledge. So we too raised this issue, and she too tried to do her best to remember what happened, and that she said that she wanted to help her brother out. So it turns out that she acted in a way that was detrimental for her daughter and for myself. Now, I don't want to engage in speculation because I can't remember very well. At the end of the day, she is available, and should that be the case, if the commission would like to also hear her, it's just right now she is abroad. She is not in Moldova. If we were to agree on another date, and if it's absolutely necessary, she would be available to come to provide to provide her answers, but I can't answer on her behalf. Understood, Mr. Gîrbu? Thank you for this answer. According to the bank statements that were available, and that were also available during the initial evaluation, we can see clearly that the funds were deposited and withdrawn periodically throughout the period during which the accounts were open. Is that correct? During the evaluation, the initial evaluation, you provided the bank statements. Yes. What I know is that at that time, I asked her if she was sent money, how was the money sent? How her brother would send the money from abroad. And she said they would use different ways. From what I can remember, I've also annexed a copy of some transfers, and there was transfers from the Russian Federation, as far as I can remember. That's where her brother used to work back then, and I think that some there was his name as well. But then later, when the commission got back in touch with me, it said that yes, indeed, there were transfers on the name or to the mother of my wife, transfers from Russia, from the Russian Federation. I can't remember the amounts, and I've also well, there was a document that the brother of the mother-in-law had this document as to the fact that he transferred the funds. And now I can't remember if he said that in the in the Supreme Court of Justice, sorry, but the mother-in-law also said that he could, for instance, ask someone in the Russian Federation, please go there because I'm here at work. Please go and transfer this money for me. For instance, he could do that too. So I can't remember very well, like 70,000 lei or, well, but so it's true that there was these remittances, these transfers to my mother-in-law. But the essence of the question is, so the bank statements show that on both accounts, while they were open, there were deposits and withdrawals of funds, and those were periodical. And those accounts were also open one after the other consecutively. The first one was opened and then closed in 2012 in February. And then in September, a second account was open. So they did not exist in parallel, but one after the other. So that was clearly established in the statement of facts. Concurrently, at the Supreme Court of Justice, your mother-in-law said that the withdrawals were only she was able to make withdrawals from one account only. Is there any way for you to explain this? I've explained it earlier as well, answering to the Secretariat of the Commission. I said that these things, these events, they happened more than 10 years ago. So it is obvious that a person might misspeak, and mm, we shouldn't do too much speculation with those statements, because at the end of the day, it was proved, as in what was kept from back then, more than 10 years ago, is that there were certain transfers. Some funds were transferred to the mother-in-law by her brother. At the end of the day, she mentioned too, she said that she signed. What I want to underscore is that it's not important that, I mean, you can't remember all the details of that. I can't remember sometimes. I mean, I can't remember with accuracy all the declarations that I filled in. So I would need to look back at that again and get into the essence of that and to jog my memory. And like I need to think back of things half year ago, and it takes some time to remember that. But so imagine 10 years ago. That's why, honorable members of the commission, I insisted on these documents to be provided in original. Understood, understood. We're just trying to clarify other aspects as well to to make a decision. Well, what I requested from the commission, I think, this could bring the light into this case, I think, and would cast away the doubts, perhaps, if that happened. But at the Supreme Court of Justice, your mother-in-law also explained, and that also comes out in the written answers provided by you in the initial evaluation, that when this Banca Sociale was about to go bankrupt, so when it was heard about it, the news was out that it was going bankrupt, she has suggested her brother to open an account in a different bank. And according to her statements, at that time, on the Banca Sociale account, at about 300, 400,000 lei. And she suggested him to open, and then she transferred from Banca Sociale, from those accounts, she transferred that over to the new account that he opened in a new bank. Concurrently, though, according to the bank statements, no transfer was identified from none of the two accounts that were registered in the name of your wife. No transfers. So none of the accounts of your brother, no transfers to none of the accounts of the mother-in-law's brothers. The question is, if you're aware about transfers like this, do you have any supporting documentation as to the fact that this money was actually transferred to other banks accounts, so that we can have a better understanding of the connection between these accounts and the accounts that the brother of the mother-in-law opened in another bank? Well, when those witnesses testified at the Supreme Court of Justice, there's I'm not sure if they actually use the term transfer, as in they transferred it like a wire transfer. As far as I can remember, out of the statements, I mean, I'm not sure. I don't know if the Supreme Court of Justice referred to you the case that it looked at. Like, did you see the testimonies and when the decisions? But as regards what they testified, especially if you have the recording, the audio recording, if you have that, as far as I can remember, because I was in the meeting during the hearing, so she or the brother mentioned, because also there were questions from the representatives from the councils of the commission, and there were questions from the members of the panel of the court. So there were questions raised about it, and she or him, one of them, said that they were transferred, but as in they were cashed out, they were withdrawn physically from the bank, from the first bank, so to speak, and then they were put, and then he went and deposited them, like cashed them in another bank. That's what I understood of those testimonies. And maybe they use the word transfer just as a simple word, as in took it from bank A and put in bank B. They didn't mean a wire transfer per se, as in, but not in that way. So I think I think that the mother-in-law said they cashed it out from the bank clerk. They took that in cash. They withdrew that money. She handed that money over to the brother, and the brother took it, and he went to Banca de Economia. And then the commission checked, and I think at the time, he told me the bank, or well, that's a private information. We don't need necessarily to know the name of the bank, but just so you know that he went there to he he took the money, and that he wanted to put that in another bank. The next question is, the first account on your wife's name was closed in 2012. It was closed in 2012, perhaps. And the second one in March 2015. And the amount that was withdrawn upon closure was 983 lei. Do you have any information as that other amount of 400,000 lei? Where was it actually? In 2015, where was it? When the brother of the mother-in-law opened those 3 bank accounts? Well, to the end of the day, let's clarify this one thing. So 400,000, it wasn't 400,000 on both accounts. I'm not sure there was together, like, I'm not sure it totaled more than 400,000. No, but your mother-in-law said 300, 400,000, 300,000, 400,000. But when you asked the questions and when you mentioned this, well, I asked, and it's like it totaled about 300 something thousand. And that's why she said that, because she didn't remember anymore. Did she open one account or did she open 2? I think that was one account, 90 something thousand, and then another one, 200 something thousand. I can't remember very well. But when she referred to both of them together, when she meant both of them together, like one was closed, another one opened, it doesn't mean that there was all that on one single account, just to make sure that we're not confused. But as I said, initially, the commission asked me about an account. When I asked her about it, the mother-in-law said, well, she referred to some account and she couldn't even remember. She wouldn't even remember the other one. She didn't remember like specifically that she opened one account or two accounts. But later, when I asked her, I said, look, and she said, oh, yes, that's what it happened. That's what it's like. And then she said, what am I supposed to remember? Things that are 10 years back, that happened 10 years back in the past? Well, apologies, but that's what she said.
Domnule Gârbu, conform
But before I forget, excuse me, one thing that I would like to mention is that the first account, I believe, I guess the first account, if you pay attention to that, it was opened when I was not even married to my wife. And this is why she was, so to speak, mad at me, and she said, what can I tell you? I said, you could have at least asked me or asked me about it so as to avoid anything happening later on. And she said, you were not even, you were not anyone meaningful to me back then. You were not married yet to my daughter, to who is my wife now. So there's just a little bit of information. Well, speaking about consequences and to make sense of the logical connections and links that were in the written communication. So look, 246,000 lei, well, let's put it like about 250,000 lei to make it simpler. About that much was released to the account holder on the 15th of February 2012 when that account was closed. The brother of your mother-in-law opened accounts in another bank, we suppose, at the suggestion of his sister, in January, February 2015. The amount, this amount of about 250,000 lei that was withdrawn in February 2012 was not deposited to the second account. The second account, you receive that information, has a much smaller amount. Do you know and can you explain how this amount could have been could have been transferred? What happened to it in 2015? So your mother-in-law, could you help me out to navigate that? Well, you said 300,000, 400,000, and but I mean all together. What I meant was all together, both accounts together. Where was this money? 250,000 from 2012 all the way to 2015. Where was this money? I don't know where they were. I am not aware of that. She said that the brother, if the brother needed something, he could send someone to either withdraw funds from that account. And then after the commission raised this question, they said that perhaps if there was a deposit, it was perhaps her who did it, or I don't know the details of this. She only can speak in general terms about these accounts out of what she can remember and something that she told me. But for her, at the Supreme Court of Justice, she testified in greater detail there. And that's why I suggest the commission to maybe hear her so that she could explain it to you. But since I did not manage these accounts, it is very hard for me to ask her where did she take the money from, and let's then move on to the next question. Mr. Gârbu, we asked you these questions. The commission asked you these questions a lot of time ago. You had time to clarify this, and there were explanations you provided during the initial explanations, such as that the money on these accounts, like all the money, is the money of all the amount, the entire amount is the money of the brother. I don't have all the proofs regarding the transfers, but to prove that this is the money of the brother of the mother-in-law, in 2015, he opened another bank account and look, all the money is there, which what the commission is trying to do is trying to understand the logic behind this statement and the link with the statement, the fact that there was the money from those two accounts of your wife that you didn't know about, as you say. Could that money can that money be actually tied to, or can we find proof of the fact that that money that money is money that the brother or mother-in-law used or took to put on his account in the 2015 account. So in the statements of the mother-in-law and of the brother, they've only mentioned about the fact that the money was transferred, from the Banca Sociale account. Since you've already mentioned it yourself, we will also say it out loud, that were transferred to the other bank. But there is no bank document testifying as to that. There's no supporting documentation that there was a transfer, proving there was a transfer between the two banks or between the two accounts but there is a statement of the brother, of the mother.
Eu am răspuns
I
cu câteva
answered a couple of seconds ago about this. I was asked about it during the Supreme Court hearings. I think they were saying transfers like something general, like moved, or I don't know what word to choose, because the mother-in-law said that they were issued at the cashier's desk at Bank A, and then he personally took them and put them next. So there was a similar question to her brother. If they were not wired, there was no electronic transfer. Okay, next clarification, if you can make it. Both in written communication and in further statements to the Supreme Court, you stated all money that was transferred by the brother were kept or deposited by the mother-in-law, and all this money that was transferred by the brother, mother-in-law's brother, the mother-in-law transferred that money then to the account that opened at the same time, bank statements show that on both accounts, while they were active, there were deposits, but also withdrawals. So this money, this amount of 300,000-400,000, they were not in neither first account nor in 2015, because in 2015 there was only 983 lei left. In the statement of fact, you have very clear, detailed data about how much money was in the account, not 300,000-400,000 lei. So according to bank data, in January, and the brother opened an account with 100,000, then another one in January with 190,000, and then a third one with 200,000. This is how can you explain in a reasonable way the connection that this was money from the two accounts that have been withdrawn, Withdrawn does not mean spent. The mother-in-law said during said at the Supreme Court that her brother was sending her money, but she did not all place it into the account. And then he opened 3 accounts where he placed the money. It's his issue. Mr. Gîrbu, the issue is understanding a logical connection between. This is how they managed it. You were saying that the brother asked his sister, your mother-in-law, to open a bank account to deposit the money. It's also you who said that she withdrew that money over time. Like you were saying that right now. In 2015, there was 983 lei left. That's a big difference between 900 lei and 400,000 lei. That's your question. Ms. Nadezhda, we are just going into speculation now. Look, when declared about these accounts, the amount that were placed, my mother-in-law meant there was 300-something thousand lei, not that at the moment of withdrawal it was 300-something thousand. Yes, she said that there have been some withdrawals over time. She admitted that from what she remembers. And maybe she doesn't remember all of the withdrawals. Okay, I understand that, Mr. Gîrbu. Would you like to add anything to this issue, or can we move to the second issue? I would like to reiterate that neither my wife nor myself knew anything about these accounts. They have no connection with us, and that's why it is appropriate to ask for the original documents in order to carry out a handwriting examination to prove that it wasn't my wife who signed there and it wasn't me. And then how it was managed and who was signing, that all these questions are out of question. No. Mr. Gîrbu, at the Supreme Court, your mother-in-law brother declared that the cash, well, that he did not withdraw cash, neither did his sister withdraw cash. And the money physically was not withdrawn. We are just trying to juggle and speculate. No, we try to understand. Regardless who managed, the main question is the source of funds. Madam Hriptievsky, do you agree with me that it is important to see who signed? Because there are so many documents, and if you say there are so many withdrawals and deposits on the account, do you agree that it is important to see who signed there? No, I cannot answer that now. So, but I take take note of your question. No, that is important. If you clarify that, everything else is out of question. That's important. Secondly, there is no evidence that I knew about those accounts, and I failed to declare. I did not use that money. No one gave it to me. I did not manage the money, and not my wife either. Mr. Gîrbu, I suggest that we move to issue 2 unless other members have questions on issue number 1 or anything to clarify.
No, ok.
I don't.
Domnule Gîrbu,
Mr.
problema
Gîrbu, issue 2 is about service housing, privatization and sale thereof. The Commission has doubts about your ethical and financial integrity in respect to the service housing, privatization and sale thereof, because of the method of obtaining as private property an apartment assigned to you as a service apartment, namely that you actively sought, including with the help of a district chief prosecutor, to change the status of a property assigned to you as service housing by removing the word service. Although the court decision assigned this housing to you as service housing, then you privatized that apartment. You never used it and sold it, although it was assigned to you as service housing, which, given its legal nature, does not include the right to dispose of the property. Again, if you wish, would you like to provide any additional brief explanation to complement your written response? Please do that now. You have up to 15 minutes, and then we will have some clarification questions on this topic. Thank you. Esteemed Commission members, with respect to the second issue, that service housing, when I was employed at the prosecutor's office, the law on prosecutor number 118 was in force. Article 38 of that law provided that a public authority, if a prosecutor had no housing or needed improvement of his or her living conditions within 1 year from the appointment of a prosecutor, had to provide service housing to the prosecutor during his or her activity in that community. When I was appointed a prosecutor in Ungheni District Prosecutor's Office since December the 5th, 2005, I had not lived there previously. I had no housing there, and I was not originally from that district. So obviously, following that right that was provided for in the law on prosecutor's office, Article 38, asked together with other fellow prosecutors who are in a similar situation to be granted, as the law provides, a service housing. The local public authority was the one which had the obligation to do so according to the law, but they did not fulfill that obligation. Obviously, as it was also found by the Supreme Court of Justice, they recognized my right as any citizen of this country when the right of a person is not observed. They have a right to go to court to ask to oblige the opposite party to respect their right. So I went to court to make sure that my right is observed. By the decision of Ungheni Court in 2008, I think it was March, my application was accepted and the decision was issued whereby the court obliged the local public authority to offer me service housing as provided by the Law and Prosecutor's Office. In this case, the local public authority, again, was not fulfilling its obligations, resulting both from the law and from the court decision, which stayed final and irrevocable. It did not fulfill this obligation until 2012, if I remember correctly, when the local public authority, from what I remember, we took the writ of enforcement to the bailiff as well to make sure that this court decision is enforced. And ultimately, in 2012, the local public authority ordered to issue a service apartment. Actually, the local public authority gave one service apartment to two prosecutors, formally dividing one apartment into two apartments with shared bathroom and kitchen, in order to enforce the court decision regarding me and regarding my colleague. This was only a formality because none of us were given a key to an apartment or something. Nothing was given to us. And again, we were forced by further verbal requests. I don't remember if there was anything in writing. We were asking to move into. I mean, if it's written on paper, let it be real. And from what I remember, around 2016, I think, we managed to get that apartment together with my colleague. But when we went there, well, in copies shared with me by the preventing secretariat, there is no CD, but in the Supreme Court, I provided pictures, even videos. I don't know if you saw that. I recommend you to see them, to see what apartment that was, if we can call that housing. That was a total disaster. For me and my colleague to be able to live there, it required capital repairs, and the cost of that was beyond the cost of the empty walls of that apartment. So then, asking the local public authority what kind of apartment did you assign to them, and I don't remember whose initiative that was. We said that if you can't and you don't give us this apartment, you don't want to enforce this. Sorry, I will read this. The law provided that if the local authority does not provide an apartment, they shall ensure the payment of rent for the entire period. But I took an abstract from the law. I will read it out just a second for us not to speculate. Paragraph 2 of Article 38 of the Law on Prosecutors Office number 118 of 2003, saying that if a prosecutor is not provided with housing as provided by paragraph 1, he shall have the right to reparation of expenses for rent until provided with an apartment by the prosecutor's office. So the local public authority was aware that for many years it has not fulfilled its obligation, the legal obligation it had. It did not execute a court decision and obligations resulting thereof. And it was aware that we had the right to get a compensation of that damage. And after so many years, from 2005 or 2006, it should have happened within 1 year. So let's say since 2006 and until 2016, when I stepped the but I couldn't live there, but still 10 years. If we make a calculation of all expenses, how much is to rent an apartment for all that time, I assure you that it was way beyond the amount of what I got after selling, not an entire, but selling my part in that apartment. Because we asked that change of mention that status in the decision that provided us that apartment, because they did not give us housing where we could have maybe not decent, but at least some conditions. And this fact was admitted and even by you, esteemed commission members, in your decision to fail, you mentioned that the commission recognizes the candidate's right to obtain or to ask for legal compensation to this end, as similar to any other citizen. And the Supreme Court specified the same thing and mentioned it, that I had the right to ask for an improvement of living conditions. And I acted for this purpose. It was a legal purpose. I did not act in any other way. And in the end, privatized that apartment with the consent. It wasn't me on my own and just taking it to myself. And as the commission mentioned in its serious doubts that I received during the reevaluation, the commission mentioned that the candidate sold even though he did not have a right. Once the apartment became private property, I did not have to ask for anyone's consent to sell or to do whatever with that apartment, because right of ownership includes right of possession, use, and disposal. And I disposed of that property. No, maybe some of us could live there, but we sold it because we couldn't improve our living conditions and we couldn't at least have what some essential needs, neither for me nor for my colleague. That apartment was a disaster. To invest in capital repairs in an apartment that doesn't belong to you, I don't know if anyone would get into such an adventure. I mean, not knowing how long are you going to keep working in that region. And neither did I have a possibility. In the meanwhile, when we asked for that, my colleague and I, we were single at that time. But after that, he got married, I got married, we got families. It was impossible to live there. By space, it couldn't. I mean, even if you look by regulatory provisions on how much living space per person should be there, that's why we sold it. I wanted that in 2006, within 1 year, to have my right respected. That's all. They failed to do so. That's why I would like to mention, I saw in the objections or when the Commission formulated its serious doubts, that the law on prosecutors office, the subsequent law on prosecution of 2008, if I'm not mistaken, I obtained the decision in March 2008, but the new law on prosecution, because it is also old now, but after the one in 2003, we had the law on prosecution of 2008, and it entered into force in 2009. So the Commission specified that in a way, it didn't that law didn't provide anymore for this right. So on this matter, I would like to invoke, again, I will quote from a decision of a constitutional court. Decision of a constitutional court of the Republic of Moldova number 9 of 30th March 2004 on controlling the constitutionality of certain legal provisions, according to which the rules on state protection, material and social assurance, including pieces, well, social assurance in this case, in the previous law cannot be annulled or changed. According to the same decision, the subjective right established based on a prior law cannot be affected by a subsequent law. The law is not susceptible to applying effect from the past. The contrary cases being against Article 82 of the Constitution. That is one thing. Decision of a constitutional court. Once I got hired under the conditions of law of 2003, my social rights and guarantees had to be observed as included in that law, especially since they were obtained by an irrevocable court decision. To this end, I would also like to draw the attention of the Commission. I actually mentioned that in my answer to Commission's opinion on serious doubts. So there is a ECHR decision of 17 September 2013 on case Antoch versus the Republic of Moldova that envisages a similar case. That person was a police employee. According to that decision, under paragraph 49, it said that the applicant does not have, no, the applicant has an irrevocable decision issued in his favor on 20th of June 2002. That is still not enforced. That decision, if you look at that, you will see that the person, in this case, was born in 1949, had a court decision issued in 2002, and the ECHR decision was 17th of September 2013. So let's do some math. From 49 to 2013, that's 64 years. So that person was not working in police anymore. And the court stated that according to that decision, the state should provide social housing to the applicant. And after the expiry of the 3 months mentioned above, until enforcement of decision, we should pay a penalty to the amounts above with a minimum interest rate to the loans issued by the central bank on that delay period. But that doesn't matter. In the end, the government recognized that because there was an amicable settlement between the government and the applicant, and it admitted that there was a violation of Article 6, Paragraph 1 and Article 13 of the Convention and Article 1 of Protocol number 1 as a result of failure to enforce a court decision within a reasonable time frame, and the government suggested to pay the applicant to pay the total amount of 4,000 euros to cover not only moral damages and costs for a period of lack of enforcement for more than 140 months. So this period of non-enforcement was calculated even for the time when the person was not working anymore for the police. But I am still working in the prosecutor's office where I started. I still work for Ungheni Prosecutor's Office. So of course, in this case, if these rights of mine were not respected and this damage caused to me was not compensated by failure to fulfill legal obligations and a court decision, then of course that would have led to another case lost by Moldova TCHR. So in this case, I only follow the legal and legitimate purpose. And I explained why I couldn't live there. That's it. Thank you, Mr. Gîrbu, and you used exactly 15 minutes that you got for that. Thank you too. Now, I would like to ask some clarification questions. During the initial evaluation and resumed evaluation, we did not receive information, so we just want to understand, we want to check if we have correct information. You did not request the local public authority to compensate your rental costs during the period that you were not provided with service housing. Is that right? Rental costs? Well, maybe we did not ask it in writing, but as long as it was not enforced with the local authority, as long as that court was not enforced, the bailiff, from what I remember, well, there were meetings and then I don't know if those papers are kept, but we said, well, I don't remember any written requests, but I think that maybe in the first request or maybe afterwards, well, I do not remember exactly, but in any way, maybe not written but verbally, we were saying that if you don't have a possibility to cover that, to give us an apartment, pay for a rental apartment for us and there's no problem. There were requests like that. I just don't remember if we made them in writing. Maybe there were, maybe not. I do not remember. Okay, in the decision by which you got the service housing, that apartment was qualified as service housing. Is that right? As provided for by the law. Yes, that was mentioned in the decision, but the law. Yes, that was, you referred to Article 38 of the Law on Prosecutor's Office, provided for the right of prosecutors to service housing. Yes. On 17th August 2015, a number of prosecutors, yourself included, asked Ungheni City Council to amend the decision of 2012, whereby service housing was assigned to you, namely to exclude the phrase service, motivating it that phrase creates impediments to the use, legal possession, and preservation of the property. Could you please tell us how service wording was creating these impediments? Impediments for use, legal possession, and preservation. I will tell you. I could not use that property, I told you. It didn't have living conditions. You explained that you couldn't live there because the apartment was in a deplorable state. I couldn't use it. That was an impediment. And how does the status of being service housing could obstruct and deplorable? I'm telling you. That status of being a service housing was an obstruction because I couldn't carry out capital repairs there, and I couldn't afford making such repairs in order for that apartment. Like, I'm done with the repairs, for instance, and I did not know. Maybe I'd be moving to another place or to another position. It doesn't matter. There was no stability. Capital repairs of an apartment were required, and that has to be viewed altogether. That was the reason I couldn't use it, and I couldn't use it because it was given to two people, which in the meanwhile created their own families, and that apartment was just a formality to fulfill a decision. If it were assigned like years ago, 10 years ago, when it was supposed to be assigned, that would be one thing. And if should it be assigned in an optimal conditions for living, that would have been a different issue. Could you please explain? So how to preserve it is a good. Could you please explain why didn't you ask also by a means of a court of law to amend the decision by which a service housing was assigned to you and to get a private property instead of service housing? I submitted that request to the council, and the council excluded that phrase, and I did not have to appeal it in an administrative way. The question is, why didn't you submit that request to a court of law? Because the local public authority executes the decision of a court of law. In the decision of a court of law states that they must assign you service housing. You asked for an exclusion of that phrase. Yes, that's what they offered us, service housing. But in the meanwhile, when we found that we can't actually start to use it, we can't live there, that's when we asked for the phrase to be excluded, not from the very beginning.
Din circunstanțele care vă le-am relatat.
We did that on the basis of the circumstances that are detailed for you. Do you think it's ethical for you as a prosecutor to ask the local public authority to make changes to the destination of a dwelling that was attributed as service housing via a court decision? I think it is ethical for a prosecutor and for any other citizen of this country. It is ethical for them to have their rights observed in this country. And I think it is ethical to claim your rights. I think it is ethical that a person who didn't have their rights observed and who suffered some prejudice to demand from the party that was at fault for failure to execute to repair the damages, so to speak, and then go to court if that is required. That would be ethical. I'm not sure that I could say that this is not I'm not sure I can say this is not ethical. So there are damages you were caused because of the failure to observe or because a right was violated. Certainly, first you go to the party that was at fault, or the party that was to ensure that your right is guaranteed, that your right is observed. The party had the obligation to make sure that certain circumstances, well, the party that need to make sure that you have what you needed, so to speak, to make it possible for that to happen. And then there's damages are supposed to be then repaired in whatever they believe to be the case. It can be goods or assets of the public, well, like public property. They could have said we could pay that to you as damages, for instance, but they believed that that was the right way. But in our request, it was just a proposal that was accepted. They've accepted it. We have to be aware of the fact. So a right was violated for a number of years. You asked for recovering the expenses from the budget of the prosecutor's office. Is that correct? As the law provided for? What did the law provide? It was from there. What exactly are you referring to? There's a law with the prosecutor's office to pay rent for you. Isn't that right? What year? Well, the law, is it the 2003 law? Yes. Well, it doesn't say that the prosecutor's office has to. It says that if the prosecutor, so that's paragraph 1, and that's the general rule that applies. So paragraph 1 provides the right to service housing and the obligation of the public administration out of the prosecutor's office, yes, for service housing. Well, then if the prosecutor was not provided housing as per paragraph 1, they have the right to damages to be compensated for rent, as in, if not damages and compensation of rent expenses until housing is provided. But it doesn't say that the prosecutor's office is supposed to compensate those costs. the compensation has to be made by the entity that didn't ensure the enforcement of the decision. But we asked you if you asked for your damages to be repaired by the LPA, and you said that you didn't remember if you filed an application in writing. Now I asked you if you filed it with the prosecutor's office, and so you didn't ask that from the prosecutor's. You mean for the prosecutor's office to compensate that to me? I did not. Because that's how I interpret it, and that is the right way to interpret. It doesn't say specifically that the prosecutor's office is supposed to pay damages. They can compensate for expenses if service housing was not provided, and that is clear. So service housing, that was the obligation of the public administration. And when it comes to expenses that had to be compensated for, it was also up to it. If the prosecutor's offices would have built a house, and this would have gone away in terms of these repairs or compensation from by the public administration. Well, you provided as an example an ECHR decision stating that a person went to the court, to the European Court for Human Rights, complaining about a situation because the decision, there was a court decision attributing housing, service housing, that decision hadn't been enforced. Is that correct? You wanted to refer to it. I'm not sure if it was social housing or service housing. It was also related to work anyway. So there was a person who went to court as a police officer, and the law on police also contains some provisions about that. I'm not sure whether it was worded exactly as in the case of the prosecutor's office, but it's like a similar case. But the essence is about the damage, that the non-execution of the decision has damaged or has been harmful for the government, so to speak. And in this regard, I'm sorry to cut you off, but that decision of the court was provided as an example because the European Court admitted that although that person no longer worked there, that person was supposed to have those damages paid. Because you, but when I say you, I mean the secretariat. Well, it was the commission through the secretariat of the Preventing Commission. I mean, well, there was a new law of 2008, and there was no longer an obligation, and it's in that context that I refer to the decision of the European Court for Human Rights. And if we were to reward, so in the case of that decision that you refer to as an example, well, that is actually a good example that shows and depicts a situation that is very different from yours, because in that situation, the person who had the right to had a decision that hadn't been enforced, and they complained about it in order to have that decision enforced. But you, through your request to change the status of the housing space, you've actually ensured for yourself that there would be an enforcement of the court decision that provided the right to service housing, not to private housing. But the way it was executed, it was also in pursuit of recovering the expenses. Should I have also gone to the European Court for Human Rights then? Is that what should have happened for the government to pay? Look, this person was given 4,000 as moral damages and some expenses, 4,000 euros. So that's everything that was there, granted. And provided that the housing would be insured to that person. Well, as a result of selling that apartment, I earned 125,000 lei. And back then it was about 6,000. 4,000, 6,000 euros, it's not a big difference. And they didn't have to specifically then, well, it was practically just the moral damage, you could say, and expenses, moral damages and expenses incurred for the court proceedings and whatever was there. So that's what he meant. All right. Yes, that is what I meant, because at the end of the day, some expenses were bypassed. They did not have to repair damages much greater. And the public administration reached that conclusion too. I mean, they could have rejected it, and then things would have gone through court. I don't have any other questions regarding this matter. I am not sure if any other members would like to ask questions, and if no other questions, then Mr. Gîrbu, over to you if you want to.
I have another question. Going back to the same issue that we just discussed. You indicated that you did not formally submit. Sorry?
Making sure that he can hear me, and now he confirmed that he can hear.
Yeah, I will repeat my question. So you indicated that you did go for a formal request to change the status of the apartment from service apartment to deleting the word service. So you filed all kind of papers in order to get that organized. But you are not able to recall whether you actually ever asked for formally in writing for compensation for the fact that you were not provided housing for so many years, as you indicated. My question is why you did not pursue that process of compensation. I don't understand it. Why did you not ask for that compensation as of the moment you were in 2008? You were given the opportunity to have service housing. It was only in 15 or 16 that you actually had access to that. So for all those years, you could have asked for compensation. That would have been a very legal approach to the whole exercise. So why did you then take the approach of asking for the removal of a service housing, where the housing, of course, was clearly meant for you in your position as a prosecutor? I'm just wondering what is the reasoning behind that.
Eu, din câte mi-amintesc, mi se pare chiar și
As
atunci.
far as I remember, I think that even then, well, I told you I didn't remember specifically about that request, whether it was verbal or in writing, but perhaps immediately after I sort of applied for service housing, it was either the response of the administration that they didn't have service housing, but as far as I can remember, but I'm not certain, I asked in writing to be paid the rent or to be given an apartment as for rent against rent payment, but I can't remember very well. I will have to look back at it and to look into that application, but maybe you already have it, that information that I'm referring to right now. But discussions about it, like verbal requests, well, mentioning that something was not executed and whether you could execute, like some verbal discussion about it, about me giving service housing and for rent to be paid for me. I mean, I engaged in verbal discussions about it. I remember that a colleague, not my colleague, but another colleague, I mean, maybe I submitted it because back then I entered the prosecutor's office when there were a number of vacancies and there was some shortage of staff. And with me and my colleague, there was another person. So it was my colleague, and another person who asked for housing. And for a while, I think they found for her, just for one prosecutor, she was the prosecutor was a woman, and she was paid rent. She rented out and the rent was paid for her, that is. But we were not given this possibility. That was not our case. But the fact that they accepted her application, it's not I mean, it wasn't a problem for us to be paid that amount or for us to be paid damages, so to speak, in terms of expenses that we incurred, but nobody offered to compensate us for our expenses, as far as I remember. And that's one thing. And the other thing is that we followed the general rule that service housing was supposed to be given, because when it comes to renting an apartment, for one to be given an apartment for rent, for the public administration needs to first of all have such an apartment to be able to give it out. But to just rent an apartment from from individual, that is also some lack of stability. You might have seen, because it was also at your request, perhaps have seen how often I kept changing the places where I lived, because at the time, if you couldn't have told someone that I want a written contract for this, and if you asked for it, nobody would have rented you out anything at all. And it was only one person that I really that I didn't find, but I found about 6, 7 people that I rented apartments from, And you see how unstable things were back then? I'm not speaking about material things like expenses, actual expenses of funds, but I was a prosecutor. I was supposed to think about doing my job, but instead I was looking all the way on the lookout for apartments because some owner would sell their apartment and the landlord would just kick me out, and then the owner, the landlord would want to move into the apartment that I was renting, and I had to move out. So it was very uncomfortable for me because my right was not observed. I had to go through all of these ups and downs with changing apartments and moving in and out. And I asked for the general rule to be observed, to be given a service housing to live there so that I could be independent in my work, so I didn't have to depend on anything without a contract whatsoever, without an agreement. I didn't want to feel like I owe anybody for living somewhere, renting somewhere. So I wanted very much to make sure that my work in the prosecutor's office is as ethical as possible. So I tended for that to happen. But and the wording here is in actively asking for, but how else was I supposed to demand that my rights be observed? Inactively? A prosecutor needs to be active and active, proactive, active in life, in personal life, in when it comes to observance of her rights, when it comes to like day-to-day life. I have to be like that. I wouldn't trust a prosecutor who is careless, who has their rights violated and they don't care about it. I'm not sure you would trust such a person. I'm not sure you would be able to trust that such a prosecutor would fight for the observance of your rights or the rights of another person if they fail to fight for their own rights when they're violated. That's exactly why the question was asked. It's quite awkward. Of course, I asked for of course, I kept actively asking for how else should I have acted if not actively? But the question was why you didn't demand what the law provided for, because there was rent, but not transfer, and not changing the purpose or changing the apartment for service housing into private housing. If there's no right to recovering the expenses, the rule was that the law provided for providing service housing, so that's what it said. And I told you what were the considerations. The commission doesn't say it disagrees with it, but it wasn't about just some apartments here and there, so that I would have to keep changing places and move in and out. But that's exactly why we said that you've actively asked for the destination of the housing to change. Well, what do you mean actively? It was just by applications or passively. How is passively or inactively? How can you ask inactively? Well, it was meant I mean, when you asked about rent, you couldn't even remember if you filed any applications, but you could have. From 2008, you could have filed it. Well, I can't remember because I knew I had a court decision, and I'm looking at it, and I remember back. I think back of it, and it says that on that date, I went there, so that's what the decision says. And out of what I said, either sometimes verbally or something in writing, and about rent, and I think I worked with rent. I can't remember all that. How can I remember that? There's a decision. If I have the decision, I read it, and I can see, and I can remember, I can recall certain things. Even today, I couldn't recall when that apartment, I took over that apartment. I need to look into the documents to remember the details of that. I mean, let's be serious. I mean, these things happened years ago, and it's natural for the memory of a human being not to remember all the details. So I don't think we should stick and cling to details like this, and I'm not sure that is serious.
Okay.
So that's
in
what
that
I
respect,
wanted
Mr.
to
Gîrbu, I have
say.
another question for you. You applied for service housing in 2008, or the request was accepted, but it was only in 2012 that the apartment was identified in which you and your colleague could be able to live as service housing. That was in 2012. That's correct?
Imediat.
Give me a second. I'll have another look. I think it was 2012.
Yeah. Okay.
Let me have a look to make sure that we are accurate.
Yeah.
fine, nu găsesc acum. Da, în 2000.
I can't find it now, but anyway, I think it was 2012. As far as I remember, it was 2012.
And when it was assigned to you in
It's,
2012,
In 2012, they made the decision on the assignment of the apartment to me, but it didn't became the owner of it, so to speak. I didn't take it at the time.
but did you at that time when it was officially assigned to you, although you were not immediately be able to go into that, did you at that
Da,
time
mi-a fost
see the
atribuit, da.
apartment? Have you seen it?
Nu l-am văzut,
Sorry?
v-am spus că nu.
I hadn't seen it. I wasn't able to enter it. I hadn't seen it because the public administration didn't even have the keys from that apartment.
And when did you see it for the first time?
În anul
In 2016. So that's why I find it surprising, because all of these things, I've already said this in the Supreme Court of Justice, and it appears to me that you are not aware of that or you don't know that. So in 2016, it was when I actually able to step into that apartment.
And you hadn't seen it also
Este-
by visiting before 2016?
Pe afară poate l-am văzut, poate pe
Well, I
afară.
could have seen it from the outside because I would pass by that building. I've rented out apartments in that region, so I would
Mhm.
pass outside of it, so to speak, but I didn't know what was there inside of it.
And-
So
and-
what is
and-
there to see? I mean, it's a building and there's an apartment in a block of apartments and a block of flats. So I mean, you see the block of flats and that's all
And,
from the outside
and when
only.
did you file
Și
the
întreba că
when did you file the request to change the status of the apartment from service housing to normal housing?
posibil încă înainte de a intra
Potentially even before I entered it, because let me think about it. I can't remember precisely, but before, when we used to, well, so I was given that apartment in 2012, we said. So we said we can't actually go there. So then at that time, it was either the mayor's office or, well, they said that that apartment was abusively occupied by somebody else who didn't have the right to live there. So they just moved in there, wouldn't leave. And out of the, or what the neighbors said, according to the neighbors, that person was using it as in they had a house or some living space somewhere. But anyway, that person didn't have any ownership rights over that apartment, the person who was abusively occupying it. And they would bring there all sorts of, if you watch the video that I submitted to the Supreme Court of Justice, there were all sorts of parts from anything, like from TV sets, like these sort of spare parts from TV sets. I think he was using that like a storage facility. And the neighbors also said that they would have all sorts of get-togethers there. There were people who were using alcohol, and often they would be very noisy. There was unpleasant smell around it. So that's what the neighbors said. That's when we realized, for instance, that we couldn't even go in. So it was like the end of the world in that apartment. And for that reason too, we said, look, there's that apartment that you've assigned to us. Let us have a look at it. Let's see what happens so that we can actually take possession of it, so to speak. And they said, look, we attribute it to you. It's yours. You go there and you go have a look. And I couldn't afford, as a prosecutor and my colleague as well, we couldn't just go in. As in, I mean, although legally and formally that was distributed to us, there was a decision and it was attributed to us. But we went to court again for the potential evacuation of the person leaving there abusively and then through a bailiff, we ultimately managed to have it over in our hands, so to speak. They took care of evacuation. At the end of the day, there was nothing to evacuate practically, because there was rather was a mess, a total mess, some old parts, spare parts, and of electronics. And I think you could see that video, and then you would understand. And that would make you also get a gist of how the mayoralty, how the local administration took care of appropriating us a place to live. So appropriating a place to live to a person. So it was obvious, but it was just terrible. When I submitted that to the Supreme Court of Justice, I think somebody asked me, they said, "What? Was that really an apartment? Or is it just you filmed? Is that a footage of something?" Because there was a lot of trash, disaster, complete disaster. Never in my life have I seen disasters like that. I mean, I've seen a lot. I've seen many cases. I've been in many sites in my life, and I've never seen anything like that before. There was absolute carelessness as to that apartment.
Thank you very much. I have no further questions. Are there anyone else who have questions? Then if that is not the case, then as per usual, at the end of the hearing, I would like to give you a very brief, an opportunity to make a brief closing statement before we close the hearing. So please, Mr. Gîrbu, if you would like to make a very brief closing statement, please go ahead.
Da, vă mulțumesc că ați avut răbdarea și m-ați
I would like to
ascultat.
thank you for bearing with me and being patient with listening to my statements. Although you did not accept my request that I've presented in the beginning of the hearing, you still took the time to examine it. You did not reject it at the very outset. You've addressed it in a discussion. You talked about it. And I would like to say that I don't know. I was thinking about all these things about external evaluation, the pre-vetting, the vetting, and this in our society, I think it's eloquent to ask this question. And obviously, when it comes to an ideal model to clarify things and to make a reform of justice happen, a reform of the prosecutor's office as well, when it comes to that, it is obvious that there can't be ideal options. Still, as I went through the evaluation procedure, the reevaluation procedure, it somehow was happening that, or I don't know if it was a coincidence only or not, but it would just happen that I would receive those questions of the commission to provide a documentation, supporting documentation to answer questions right at the moment when I was either, for instance, very engaged with some work duties, something that couldn't have been postponed, and I was like, all my attention was there, so I didn't have the possibility I didn't have the possibility to actually find all the documentation, find all that information at that time to be able to ensure that a proper multifaceted evaluation can be carried out. Even today, or like yesterday, I was involved with my work, and today in the morning too. And obviously, you have perhaps heard about the latest events in Ungheni District. There were some unpleasant situations taking place there too, and so it's as if several things happen all at once, and I don't know how things should have been different. Maybe for candidates for the future, and it would be for the vetting, for instance, for them to be given time off from work or some time off from work to be able to respond to this request, because I looked at looking at the prosecutors, I think there was about 17 prosecutors. Some withdrew at the end of the day. This is a big number, but as it was estimated that for the vetting, there would be the number of those who would participate would be about 220 prosecutors, which is about a third of all the employees of the prosecutor's office, especially in key positions in specialized prosecutors' offices. So given that, I don't know what the impact of this would be on that. At the end of the day, what will be the impact on their work? Because it's like you have to make a choice to choose between managing to provide all the documentation and all the information that was sought and to present your position in the right way, in a multifaceted way, and then you have to choose between that and comply with your or discharge your job duties. So it's you like you have to do this in parallel. And I believe that there's some overlapping and it's somewhat complicated and it makes there certain things harder to do. And in addition to that, for the pre-vetting, I would say that there is also this sanction that if you don't pass, you can't run for a position in the Superior Council of Prosecutors. And you know what the outcome of the vetting is, what the sanction would be, what the penalty would be for the vetting. And if there's a prosecutor, imagine a prosecutor who's managing so many cases when they have a lot of work, especially those who are in key positions in specialized prosecutors' offices who deal with very important cases, high-level cases that are important for the country, entire country. For instance, you can imagine, like, if you look at it, it's quite stressful. And if you look at it through the emotional lens, it's quite a lot of stress. And it's, I mean, what guarantees would that person have about being able to live up to all their commitments? I think it should be something very extraordinary for a candidate not to be passed. So something that is really out of the ordinary for a candidate to be failed, something really serious, outstandingly serious situations. And even income and expenses, they should be there should be investigations performed thoroughly to the bottom of it, and the commissions need to be certain that they didn't make a mistake and that they didn't arbitrarily fail certain candidates. And that is what I wanted to say, and I hope that I was heard. I've always used the law to guide my actions. I interpreted it to the letter, and I observed the prosecutor's code of ethics for the position that I have. A person cannot be ideal, yet any person, anyone, only those who do nothing, only they make no mistakes. But in general terms, I think I meet the integrity and ethics criteria to be passed, but that is up to you to decide. I believe, though, and I know that you know too, that we have to respect the final irrevocable decisions of courts of law, because that is the essence of the rule of law, of a government, of a state that follows the rule of law. And I was thinking in this context whether there are certain decisions should be respected or not, certain decisions that one way or another are not objective, should you? But I was thinking, if I was a prosecutor and if I went to court, because you can see this, when it's administrative or civil, it's something else, but in criminal cases that is more eloquent. I can't imagine going to court, to the Court of Appeal, for instance, where it's a preventive measure. For instance, if there's a person taken into custody and the Court of Appeal would, for instance, reject, for instance, not myself or some other prosecutor, well, say that they would reject the request of the prosecutor to maintain the preventive measure of custody, for instance. And so a situation where the decision, for instance, of the Court of Appeal would be irrevocable, and the prosecutor to say that, oh, I don't know if I will implement this decision because I think it's arbitrary, and thus I can't imagine them keeping a person in custody after an irrevocable final decision on that case. So that's what I want to say.
I'm sorry for interrupting
When we
you, but I
have
think
to
it was,
observe the
I was
decisions of court.
Scuze
I was
dacă
asking you for a
prea mult s-a
brief
întins.
closing comment in relation to this process. I don't think we have to discuss the responsibility
că
of
v-am
judges and
reținut.
prosecutors in Moldova.
Sorry for taking
they're
too much
very-
of your time.
But okay, then I would suggest that we wrap up. We come to the end of this hearing. We have certainly heard you this afternoon, and of course have also carefully studied all the materials that you sent to us and other materials that we have collected. I thank you for providing the answers and be with us this afternoon. And as you know, the standard practice is now that a commission will withdraw for deliberations and prepare a decision, and we hope to be able to deliver a decision within a month after the date of this hearing. With that being said, I declare this hearing closed and wish you a safe trip back home. Thank you very much.
Mulțumesc, vă doresc și eu numai bine.
Thank you. Wishing you all of the best.